I'm your host, Hillary Bricken, and this is the Cannabis Law Now podcast, where we regularly discuss issues related to the cannabis industry, including investment, day-to-day operational issues, and potential reform on the horizon that will impact all cannabis businesses and investors in the United States. Hey, everybody. Welcome to the podcast. Today with us, we have a very exciting guest that I was super glad to net with his very busy litigation schedule. We have Josh Schiller from Boies Schiller Flexner, LLP. And if you haven't heard of this law firm, you've probably been living under a rock. But Josh in particular is very interesting to me because he's about to do huge things in cannabis if they've not already been accomplished with this filing. But Josh is admitted in New York and California. He's a seasoned trial attorney. He litigates all sorts of civil matters in the U.S. and abroad. And this is why he's on today, because he's one of the lawyers doing the Lord's work representing plaintiffs in the Canna Provisions Inc. et al. Versus Garland case. And this case is important and super notable because it is the most recent, I think, legitimate constitutional challenge against the feds regarding essentially the fate of cannabis on the Controlled Substances Act. And it was filed in October of 2023. So welcome, Josh. So happy to have you.
Thank you very much, Hillary, for that wonderful introduction. It's nice to be here.
Okay, great. And for the benefit of our audience, I'm just going to launch right into these substantive questions. Appreciate you talking about it with me. Feel free to add anything else off the script from these questions if you want to, okay? Just so everybody knows out there, what are the basic claims in this lawsuit?
So the lawsuit is based upon the constitutional powers invested in both federal government and the states as the Constitution was originally set up. The federal government has limited power to enforce commerce in the United States when that commerce involves transactions that are considered to be interstate commerce. And interstate means commerce that travels amongst or between the states. The federal Constitution does not give our federal government the power to regulate intrastate commerce, meaning commerce that is entirely within a state. Now, there was a challenge back in the early 2000s based upon the Bush administration's, what I like to call the last act of the war on drugs, when the Bush administration decided, when I was in law school, to start raiding medical marijuana growers and I say growers because they literally went in and threw a woman in jail who had 12 pots to treat her glaucoma in Oakland. But they made a big point about shutting down the California lawful intrastate market for cannabis or marijuana. I like to use the word marijuana. It's a little more narrow than cannabis, but cannabis obviously has all kinds of medicinal uses. But, the Supreme Court heard that case, and it's called Gonzalez v. Reich, and determined that on the basis that the federal government's policy at the time, and I say at the time because it's a key factor in the way we've written our complaint, was to use their commerce power to eradicate cannabis or marijuana throughout the entire country from what they described as a black market for marijuana. And so if they were to allow entirely intrastate market to exist lawfully under state law, they still had concerns that cannabis would make its way to other states and to black markets. And so the court, in a decision that was criticized quite strongly at the time by Justice Thomas, and was joined, interestingly enough, by some liberals and some conservatives. But I say that only because we have a very different court now. But they determined that it was a lawful use of the federal government's power to enforce that policy. It was a legitimate use, in other words. Now, ever since then, cannabis has not gone away. The federal government has taken steps rather to eradicate it, but to make it more lawful, more accessible, and to take away its own power in what Justice Thomas recently described a few years ago in a dissent in a prosecution in Florida, an appeal from a prosecution, saying that federal government's policy these days is half in and half out. And that's not a legitimate use of the federal Commerce Clause power. And so what we've tried to do in our complaint is illustrate that with facts. And when we get to summary judgment, assuming we get to summary judgment, we will be putting forth evidence to show that the federal government's policy ever since that decision has been inconsistent, that the federal government is allowing these businesses to lawfully operate intrastate without any concerns about this so-called black market for cannabis. And in fact, we'll also introduce evidence as we collect it to demonstrate that the black market has been harmed, if not reduced, by the availability of safe, regulated marijuana products in almost 38 states at this point.
Fantastic. I love the complaint, by the way. As soon as I saw the filing, I grabbed it because I think lawyers that have been in the industry are very concerned about differentiating it from Gonzalez versus Reich. Well, we'll talk about that towards the end. But another question, just on the technicalities, especially for folks, lay people not attorneys that are listening to this podcast, what relief are these plaintiffs seeking? And if you could talk a little bit about the plaintiffs, what are they? Are they retailers? Where are they located? That kind of thing.
Well, as you can tell, we took a lot of time in thought and care in putting it into this complaint. And when we started working on this case about a year and a half ago, we looked at a couple of states because we wanted to understand how the lawful intrastate marketplace was working. And, we were primarily being brought concerns from the industry, concerns that I'm sure your clients have expressed to you. The discriminatory taxes they face under 280E, the unequal treatment they face in getting insurance policies and having to employ extra security and having to mostly be cash operated businesses, top to bottom, getting mortgages, getting small business loans, the normal things that small businesses in America depend upon that our federal government subsidizes and uses. Well, tax is not a subsidy, but it's a penalty as these companies face it. We knew what the concerns were, but we wanted to look at the case and deconstruct it and say, where's a good example of an intrastate market that is lawfully run, that is well regulated, where we can demonstrate people as examples of this growing entrepreneurial American industry. And we ultimately decided on the Western District of Massachusetts because we had a number of reasons we wanted to use Massachusetts as an example. It's not the most recent state, but it's been around for a while. It took them a while to get their products regulated and on the shelves. And they have a very strong lawful market. And so we wanted to also take a slice of the industry and show the court the different kinds of companies and how they're being affected. And so we have a distributor, we have an MSO, and we have a farmer. We have an interesting aspect of different pieces of the industry. I like to say that each one of them tells their own entrepreneurial American story, and each one of them is able to demonstrate in different ways and in similar ways that the harms that they face in not just starting their small businesses, but maintaining them successfully. You'd ask me about the relief, and the relief is to seek an injunction, not to reclassify or declassify or tell the FDA what to do, because we can't do that. But we can ask a judge to say the use of the Commerce Clause power as applied by the FDA as a Schedule II drug, and the use to enforce that against businesses that are otherwise lawfully operating intrastate is an unconstitutional exercise of the Commerce Clause power, and therefore we'll have an injunction against it. Now, that is very narrow and very limited. It doesn't mean that the federal government can't still, prevent interstate commerce. It can't arrest truck drivers who are driving over borders. It can still do that. And I would maintain to you that after our case, I think the federal government, if we're successful, will likely work towards a structure where they may decide ultimately to regulate marijuana or leave it entirely to the states. But as long as they leave it entirely to the states, the effect of our lawsuit should be to get rid of all of the penalties imposed by federal regulation. And so while we're aiming to help folks in Massachusetts, our goal really is to help everybody in the country who is operating these businesses and investing in them.
And federal penalties, including the draconian impact of 280E, right?
Right. Well, that would be a side effect. It's not the main target for this case, but for those businesses who want to know how to work to get the benefits of our case if we're successful, we are talking to lots of clients since we filed them before about how to take administrative steps, something I'm sure you're familiar with. But the process of a tax appeal is different because you can't bring a class action on behalf of taxpayers, right? They all have to exhaust their administrative remedies and appeal individually. And so some businesses we've spoken with are already taking steps to do that, anticipating or hoping that we win. And I could see one of the effects of this case, if we're successful ultimately, is that there will be a number of companies that will be looking to the federal government for a very large tax refund. And that would be a fun day in court if we get there.
I would wholeheartedly applaud that. Moving on, I think many people are not accustomed to just the length of litigation, regardless of the subject matter. What do you think the basic procedural timeline is here for this case? And personally, what do you expect to happen in the district court, which, ladies and gentlemen, is the federal court where the initial filing takes place?
So we've agreed on a briefing schedule with the federal government this week, and they're going to file either an answer to our complaint or a motion to dismiss, they haven't indicated yet, on January 23rd. And we'll respond to that in March. And if it's a motion to dismiss, it will be fully briefed by the first week of April. And then there may be a hearing. I would expect an oral argument and hearing on that, maybe as soon as May. If that doesn't happen and they file an answer, then what we would be seeking to do is to go to summary judgment, within a reasonable period of time. And because this isn't a case where we're going to be taking depositions or we're going to be looking at emails, this is really about the facts that I don't think are going to be in dispute. What is the federal government doing now versus 15 years ago? And what are these states doing now versus 15 years ago? And how are they lawfully regulating these businesses? And how are these businesses benefiting their communities? And that's not going to be controversial stuff. It's going to be simple, a demonstration of what's going on in this industry. And the federal government will have a legal basis to argue against us. But if they answer and we get to summary judgment, this case could be decided next year. That would be the fast track. If a motion to dismiss is granted, then we could be appealing that. And that decision could be the vehicle that gets through the appellate courts. Although I would rather, obviously, have a summary judgment record because I think it's a better demonstration of the evidence, obviously, and it's more for the courts to consider. But, assuming that we get past the motion to dismiss, I still think that summary judgment next year is possible with an appeal the following year, because either side will appeal either a victory for or against the injunctive relief that we're seeking. And so if we get to a year and a half from now, we're preparing for argument in the First Circuit. And I think we've done very, very well. That's a relatively streamlined time frame for a federal case in litigation, but I compare it in some ways to the gay marriage and the marriage equality cases that we brought after Proposition 8, which at that point in time, the record was already made by the initial case in California, which depended heavily on the state court record that had been tried several years earlier. But the government, when we litigated that case, agreed with us that those cases should proceed quickly to summary judgment. I wouldn't be surprised if the government was able to agree with us on that issue here and present their view of the facts and their view of the law. It could be a very easy case to get to an argument.
Okay. And any personal feelings about what the district court's going to do here on that motion practice, whether it's a motion to dismiss or an SJ?
Well, we're hopeful that the court will give us an opportunity to present the evidence at summary judgment, and looking at the evidence, we'll feel empowered to say, this is a different case than the Raich v. Gonzalez case for these reasons. The federal government's policy isn't the same. And I think if the court can get to where I am with that issue, then the court can independently assess whether the policy is still being enforced in a legitimate and rational way, because the impact on intrastate commerce is quite strong, and that legacy of cases going back to the 1940s has always been something that legal scholars like to debate the validity of, because again, you have to start with the principle that the federal government does not have the constitutional authority to regulate intrastate commerce. And so why should that limited exception continue to be applied in this important and growing industry in America? And if the court is able to consider that and the impact on its communities, I think it could reach a different decision than the courts did in California.
Fair enough. Fair enough. Now, this is highly speculative, but you've been there before. Do you think this has the chops to make it before the Supreme Court of the United States in a basically quasi-Gonzalez versus Raich 2.0?
There will certainly be an argument for the court to hear this case if, for example, the district court and or the I keep saying that I'm a New York lawyer, the First Circuit takes our case and grants the injunction or upholds it. Then, one could argue that there's a split between the Supreme Court's prior decision, which is unusual, right? and the circuit court's decision. But, we think that this court, which is ideologically run by a group of conservatives, primarily, but Justice Thomas has been consistent on this issue and his criticism of that prior decision for 20 years. And so we think we have his vote. Now, is he able to get 3 others to vote to hear the case? I think he will be able to do that. I think these kinds of issues are very important, but also they're very interesting to Justice Gorsuch, and I imagine to some of the other Federalists on the bench as well.
And, talking about this 1940 precedent that all the lawyers know because they went to law school. And I'm talking about Wickard versus Filburn. And then, of course, Gonzalez v. Raich and what we got out of the Ninth Circuit and ultimately the Supreme Court. Can you give me maybe the top 2 or 3 biggest distinctions between Gonzalez versus Raich and now?
So, in Wickard is a case that lawyers are familiar with. It's very controversial and fun to debate when you're a young lawyer studying the Constitution. It said that, a farmer in the Midwest wasn't allowed to use the wheat he grew on his property for his own personal use and consumption during a crisis that the government determined was necessary, a wheat pricing crisis that caused the government to say, we're going to limit every farmer in America to 20 bushels of wheat. I'm sure that decision seemed very unfair to that farmer now, as it does today to many people who look at the limited powers of the federal government under our Constitution. What I've said consistently is we're not trying to overturn any precedent. We're just trying to get the court to examine the current policy. And I think, although I'm not familiar with too many cases where the federal government's policy has changed so dramatically over time that a case has been, reconsidered or considered in a different way. One of the arguments that I think we have a strong ability to present as a factual record, they said all wheat is the same. It's a fungible commodity. Whether you buy wheat in Oregon or Arizona or Wisconsin, it's all the same. And, I think they were right about that. On the other hand, they reached the same conclusion that all marijuana is the same and it's a fungible product when they ruled against the medical marijuana industry in California, early 2000s. I think the industry has changed a lot. All you have to do is go into one of these stores today and see all of the different kinds of medicinal products that are there, whether it's a retail store or a medical facility. There are gummies for sleeping. There are vaporizer devices of all sorts. There are potato chips. There's lots of things I'm never going to try in these stores, but there are unique products in each state, and they're very different. The marijuana you buy in California is very different than the marijuana you buy in Massachusetts, and that's a good thing. It's like wine in a way. It derives its strength, its potency, and its flavors and effects in part from the dirt where it's grown. And so that's one way we can distinguish those two prior cases. But ultimately, our focus is really on the use of the power. Okay, was the federal government's protection of pricing of wheat legitimate at the time? I don't think we need to go back and debate that issue, but at least at the time it was recognized it was important because they thought if some farmers are able to do what this farmer's doing, they're not going to buy any more wheat. And then the price is really going to continue to be depressed. Now, we think that the federal government is no longer intent on eradicating the black market for marijuana, that it doesn't have to have that purpose in mind by having these effects imposed upon lawfully operating intrastate businesses, because we think that those businesses are actually reducing the amount of criminal activity in the industry because they are providing a safe, regulated product for dads and moms to go buy after they buy a bottle of wine on a Friday afternoon. It reduces the need or the desire for anyone to do a black market transaction. And so the more that the fact that they're in 38 states really shows that the majority of the country feels that these products are safe, enjoys consuming these products, and wants them to be lawfully regulated and available.
Do you think that the feds would argue, though, that there are certain states where it's not tight enough? There's too much diversion. The program's not strong enough, maybe in line with one of the previous enforcement memos that came out from the Department of Justice. Because I know Massachusetts is a great jurisdiction. They're tightly regulated. They do their best to prevent diversion, but there are other states, admittedly, probably California, that have diversion problems. And I would throw Oregon in there too. That's common knowledge. Do you think that's going to come out as a curveball?
Well, I think it will. They will argue that there's still a problem there. In response to that, I can say two things. If you read, like in the last 6 weeks, New York made a substantial effort to crack down on these illegal shops that are highly criticized. And whether or not that cannabis is coming from Oregon and California, I think is debatable. I walked in one of these shops when I was in New York in September just to see. And I've had a couple of people in the industry tell me they're making it look like it's coming from California because they want you to believe it's the same product, but it's really just a fake. I don't know whether that's true or not. What I do know is you can tell what the real products are. And as a consumer, if you want to help our case, don't buy those illegal products. Let the state government shut them down. They're not good for the lawful businesses. They're not good for the industry. They're not good for you. But if you buy the products that are regulated and stamped locally, and you know where they're coming from, you know that community is benefiting from your transaction there. I think that if the federal government makes that argument, we can say, look, these states have the power and they have the incentive to shut down all illegal activity, in particular if it's going out of state. And, there has been a commitment by several states, including California and Oregon, to ultimately try to figure out the problems with illegal interstate commerce if and when they have the power to do that, if the federal government decides to step back. I think there are lots of solutions, but saying that they need to continue to treat these businesses throughout the country as illegal businesses just because there's some leakage, there are ways to deal with the leakage without causing these penalties on the lawful businesses.
I like it. Okay, I have two more questions for you before I let you go. Number one, what are the downsides if you don't prevail? Is industry left status quo? Are they left worse off? What do you think?
There's no downsides. I mean, if we get thrown out or if we never get back to the Supreme Court, then we've tried. And, we have a group of people committed and supporting this. The level of support continues every week. We encourage people to advocate for us and to support the case if they want to. We'll have tried. The reason that we brought the case now is in part because we're looking at the court differently than we were 4 or 5 years ago. And in part because while the facts have been there for a while, I think they're very strong right now. And we have a legislative record that is it's almost unbearable to take, because for 7 years, I keep getting told by people in the industry, the solution is right around the corner. It's going to happen next year. And we just see it. We see all these attempts to do reasonable things to get bipartisan laws passed that have an overwhelming amount of support that never make it to the cutting floor. And now we have a speaker who's notoriously spoken against marijuana. And so he's sort of got his thumb on the scales. And, while these other efforts, including, reclassifying the scheduling of the drug would have a great impact, we hope those things happen, but they won't achieve the full satisfaction of what we can achieve with getting rid of federal criminalization entirely.
Right. And I just want to emphasize to listeners, even if a reschedule to 3 occurs, we still have a whole state-based adult use and medicinal market that deserves protection. And we probably can't rely on lawmakers to ensure that, or it's going to get really weird otherwise. But I digress.
Do you want the FDA to regulate marijuana so that you can only do it through a prescription? That would be worse.
I'm with you, Josh. That is not the regulator of my choice in this scenario. But okay, last question. It's a bit of a silly one and it's a touchy-feely one, but I got to hear it from you. Why take on this case, especially in light of all the other civil rights matters your firm has worked on? Why take this one?
Well, we love these cases. We love these hard cases, particularly with growing industries like we did with DraftKings several years ago, saving them from the auspices of the New York Attorney General and the crosshairs of many other attorneys generals. But, with a new industry, and I call it a new industry, even though it's been around for 20 years, it's new to where it is in many states. And I think it's really an important case because in America, we don't have a lot of, other than technology, new industries that have been invented in the last 20 years. And this is a growing industry that I think the rest of the world is also recognizing. I mean, all of North America has legal cannabis now. So why should our federal government continue to impose these problems and impede the growth of this industry, which is contributing to communities in ways that farming hasn't been sustained? It's a way to rehabilitize some communities around the country that have suffered where industry has left for 100 years and not come back. And hopefully the courts will recognize this. I genuinely think Congress does. I just think the problem is that they're Congress. And so they can't get reasonable things done efficiently. And if they could, this would have been done a long time ago. We think that this is there's just a need at this point. I mean, I've been looking at this case for about 5 years as the industry really started to grow after California. And certainly Colorado was the leader, but California really opened up a huge amount of industry. And we've seen a lot of people follow. And so we want to protect these industries. We want to protect this entrepreneurial American spirit. And we see this as a really important case, even though it's a commercial one. It's not a pro bono case, but it's an important industry. And they are really suffering for what I would call unnecessary and discriminatory practices.
Fair enough. Well, Josh, thank you so much for your time. I think we're all better off from having heard it directly from you. Very exciting lawsuit. I wish you the best of luck, and we'll certainly be watching. Thanks.
Thank you. Very nice to meet you as well.
And that concludes today's episode of the Cannabis Law Now podcast. Until next time, stay alert, stay alive.